We often hear about employees leaving with company secrets, and you might picture, I don't know, some kind of spy movie plot.
Yeah, trench coats and briefcases.
Exactly. But what happens when it's a programmer switching jobs and a seemingly straightforward situation just spirals into years of legal fights?
And it forces us to ask these really big questions, right? About tech, about value, justice, especially in that pressure cooker environment of Wall Street.
That's the perfect setup for the story we're really digging into today. Sergey Aleynikov, he's this programmer, leaves Goldman Sachs, and bam! Suddenly he's in the middle of this huge legal storm.
All because he allegedly stole proprietary code.
Right. And to get our heads around this, we've got a couple of great sources. We're looking at excerpts from that Michael Lewis piece in Vanity Fair. Really gripping stuff.
And also the Wikipedia entry for Sergey Aleynikov, which gives us that factual timeline, the legal specifics.
So our mission here, for you listening, is to really unpack this. We want to follow the timeline, understand this whole high-frequency trading world it happened in.
Yeah, which is pretty wild in itself.
Totally. And look at the legal arguments, from both sides. And then step back and think, okay, what does this whole saga actually tell us about finance today and how we even think about digital stuff like code? Is it property? What's it worth?
Okay, so let's start at the beginning. Sergey's background. It's quite a story, actually. He grew up in the Soviet Union.
Right, and even with all the restrictions there, he got really into programming, found a passion for it.
That's right. He came over to the U.S. Around 1990, I believe. Worked in telecom for a while. And then eventually Goldman Sachs recruits him in 2007.
And what's interesting, according to Lewis, is his first impression of Goldman's tech. You'd think Wall Street, cutting edge, right?
Yeah, super advanced.
But he apparently found it surprisingly clunky, outdated compared to what he knew.
Which is kind of fascinating. And Goldman's reason for hiring him was pretty clear. They were lagging. Their high-frequency trading platform needed speed boost, basically, to keep up with competitors.
So his job wasn't initially build the next big thing.
Not really, no. A lot of it was maintenance, patching up this older, sprawling code base they had. He did work on decentralizing things, trying to shave off those crucial milliseconds for trading.
Ah, okay. So breaking it down, making it faster that way.
Exactly. Instead of one big brain doing everything, spread it out, makes it quicker.
And what about the Goldman culture? What was his take on that?
Well, the picture painted is very competitive. Huge focus on bonuses, naturally.
Standard Wall Street, maybe?
Sort of, yeah. But also, maybe surprisingly, not that much collaboration between the programmers themselves, kind of siloed.
Interesting. And Lewis mentions Sergey saw finance itself as more of a game.
Yeah, a gambling game, I think was the phrase. His real interest, it seems, wasn't the trading wins or losses, but the engineering puzzle. How do you make these systems just incredibly fast? That was the challenge for him.
Okay, so that kind of sets the stage for him leaving. He gets this offer from Tisa Technologies in April 2009, new hedge fund.
And it was a very good offer. Reportedly triple his Goldman salary. We're talking over $1 million a year.
Wow, okay.
But it wasn't just the money, apparently. He was really drawn to the idea of building a totally new system, from scratch, a clean slate.
So he resigns from Goldman. That's early June 2009.
And this, right here, is where the whole thing ignites. Barely a month after he leaves, July 3rd, 2009, he's flying back from a visit to Tisa in Chicago, lands at Newark,
And gets arrested.
By the FBI.
Okay, the timeline is super tight there. Goldman finds out code was downloaded. When?
Just a couple of days before the arrest, according to reports. And they moved incredibly fast. Called the FBI almost immediately.
Wow, that is fast. And the initial FBI investigation, how deep did they go technically?
Well, that's a key point. It seems, at least initially, they relied pretty heavily on Goldman's side of the story, their explanation of what the code was and why it mattered.
Right. Michael Lewis points out the arresting agent. New finance, maybe, but not the deep tech stuff, not high-frequency trading code.
Yeah, exactly. Not the nuances of source code, version control, open source, all that stuff, which becomes really important later.
So what was the code he downloaded? What are we talking about here?
It was about 8 megabytes, which in the grand scheme of things isn't enormous,
But significant, maybe?
Goldman certainly thought so. And he apparently sent it to himself or to an external server 4 different times. The code itself was a mix. Some of it was open source software.
Okay, stuff that's publicly available.
Right, but code that he'd worked on, modified, integrated while at Goldman. And then there was Goldman's own proprietary code, stuff he'd also worked on or helped develop during his 2 years there.
Got it. And what was his reason for taking it? Why did he say he did it?
This is crucial. He said he downloaded it primarily to pull out the open source parts he'd worked on, to kind of disentangle his contribution. Because, he claimed, Goldman wouldn't let him contribute his improvements back to the open source community, which is something programmers often want to do. So he wanted to keep a record of his work on that specific code.
Okay, that's his explanation. And this thing about sending code to himself, was that weird? Was it unusual?
Well, according to him, and later supported by other programmers, not really. He said he'd been doing it pretty regularly, like weekly, for his entire 2 years at Goldman, sending code snippets or files to his home email or server.
And nobody flagged it before.
Apparently not. No one raised an issue until he was leaving for a potential competitor.
And there was also this business about deleting his command history, his bash history.
Right. He wiped his command history. The prosecution painted this as suspicious, like covering his tracks.
But he said
it was just standard practice for him, like digital hygiene, to remove his password, which might have been temporarily stored or visible in that history. A security measure, basically.
Okay. Then comes the FBI interrogation. That sounds like a real point of contention.
Definitely. Lewis's account suggests Sergey tried to explain the technical side, the open source stuff, why he downloaded it, the bash history, but felt the agent wasn't really getting it or was maybe dismissing it.
And he ended up signing a confession.
He did sign a statement. But he later claimed it wasn't fully accurate, that it was sort of shaped by the agent's misunderstanding of the tech details.
Did the agent comment on that?
The agent later acknowledged, apparently, that, he relied mostly on what Goldman people told him and didn't bring in an independent tech expert at that stage.
Okay, so all this leads to federal charges. Big ones.
Oh, yeah. Theft of trade secrets, transportation of stolen goods across state lines, and also illegally accessing a protected computer to get information. Serious stuff.
And the verdict?
December 2010. He's convicted on 2 counts, the trade secrets theft and transporting stolen property. And the sentence was pretty hefty. 8 years in prison.
8 years. Wow. But that wasn't the end of it, was it?
Not even close. He appeals, obviously. Goes to the Second Circuit Court of Appeals. And in February 2012, they throw it out. Unanimously. They reverse the conviction entirely, order his acquittal.
Whoa.
Right.
Why? On what grounds?
It got really technical and legal, but basically, they looked at the laws he was convicted under the National Stolen Property Act and the Economic Espionage Act. And they decided that, as the laws were written then, the source code didn't quite fit the definition of a stolen good being transported.
So, like, code wasn't a physical thing?
Kind of. And under the Espionage Act part, they ruled it wasn't related to or included in a product that is produced for or placed in interstate or foreign commerce in the specific way the law required. It was a very close reading of the statutes.
Okay, so federal acquittal. Surely that's it. He walks free, case closed.
You would absolutely think so. But no. Just a few months later, August 2012, he's arrested again.
You're kidding. By who? For what?
This time, it's the Manhattan District Attorney. State charges. But based on the very same conduct. The same code downloading incident.
Wait, isn't that double jeopardy? Can't be tried twice for the same crime, right?
That's exactly what his lawyers argue. Forcefully. But the legal argument is complex state versus federal charges, slightly different laws. The courts allow the state case to proceed.
Unbelievable. So what were the state charges?
Unlawful use of secret scientific material, that was one. And unlawful duplication of computer-related material.
And how did that trial go?
It was another roller coaster. The jury acquitted him on the computer duplication charge. But they found him guilty on 1 count of the unlawful use of secret scientific material.
Okay, so a guilty verdict on 1 count.
But yeah. The trial judge reviewed the verdict and dismissed it, basically saying the prosecution hadn't met the legal standard for that specific charge.
So, acquitted again? Kinda?
For a moment, yes. But the Manhattan DA wasn't giving up. They appealed the judge's dismissal.
Of course they did.
And the appeals court, the appellate division, sided with the DA. They reinstated the guilty verdict.
This is dizzying. So where did it end up?
It went all the way to New York's highest state court, the Court of Appeals. They ultimately upheld the appellate division's decision, meaning the guilty verdict stood.
So he was found guilty in the end on that 1 state charge.
Yes. But by the time sentencing finally happened, which was way later in 2018, he was sentenced to time served.
Ah, because he'd already spent time in prison after the initial federal conviction.
Exactly. So a conviction on his record from the state, but no additional prison time. A really winding, exhausting legal path.
Wow. Wow. Now, Michael Lewis, in his article, he talks about this sort of second trial he conducted, right? Talking to other tech people on Wall Street.
Yeah, that's a fascinating part of it. He spoke to a bunch of technologists, people who really understood high-frequency trading systems, coding, the whole environment.
And what was their take on Sergey's actions?
Overwhelmingly, Lewis reports they found his actions kind of normal, or at least understandable for a programmer. They bought his explanations for why he downloaded the code.
So the people who actually do this kind of work didn't see it as some massive theft.
Generally, no. The perspective was quite different. Goldman saw it as stealing the crown jewels. These programmers saw it more like taking your notes with you when you leave a job.
Huh. And they were surprised he didn't take more. Or something else.
Yeah, they were apparently surprised at how little code he took, relatively speaking. And crucially, they noted he didn't take what they considered the really valuable stuff, Goldman's specific training strategy.
Scrats.
Exactly. The algorithms that actually decide when to buy and sell. That, to them, was the core intellectual property, the real secret sauce. Not necessarily the infrastructure code, even if it was proprietary.
And they had this analogy like a notebook.
Yeah, like a programmer's code repository is their personal spiral notebook. It's how they remember how they solved problems, techniques they use, you refer back to it. It's part of your professional toolkit, in a way.
That's a really different way of looking at it than, say, a bank protecting its vault.
Completely different perspective. And these technologists, they were also pretty skeptical about Goldman's reaction. Why go so hard after him?
What did they speculate?
Lewis suggests they wondered if it was partly about protecting the image of Goldman's tech prowess. This idea of in-house genius building everything from scratch.
And if it came out that a lot of their system used modified open source code.
Maybe that slightly dents the image.
Yeah.
And potentially impacts how bonuses are justified. That was some of the speculation Lewis encountered, protecting the narrative maybe as much as the code itself.
And Sergey himself, through all this, how did he seem?
Lewis portrays him as remarkably calm, almost detached, philosophical about the whole ordeal, even after years of legal battles and prison time.
That's quite something. And his story, this whole case, it actually sparked something bigger, didn't it?
It did. It was the direct inspiration for Michael Lewis's book, Flash Wars. That book really blew the lid off the whole world of high-frequency trading for a lot of people, explaining its complexities and controversies.
Right, brought it into the mainstream conversation. And there was a legal change, too, after the federal acquittal.
Yes. Congress actually passed the Theft of Trade Secrets Clarification Act in 2012. It was designed specifically to amend the Economic Espionage Act to close the loophole, essentially, that the court found in Sergey's federal case. To make it clearer that stealing proprietary economic information, even intangible stuff like source code, is covered.
So future cases might play out differently because of his case.
Potentially, yes. The legal landscape shifted partly in response to this.
Now, we have to be fair to Goldman Sachs here. Their position remained consistent, right?
Absolutely. Throughout the entire process, their stance was unwavering. This code was incredibly valuable, it was proprietary, it was a critical trade secret, and taking it was a serious breach of trust that damaged their business and competitive standing. They felt fully justified in pursuing the case.
Okay, so bringing this all together, what are the big takeaways here?
Well, it's just a hugely complex situation, isn't it? You've got this clash between cutting-edge technology, the insane pressures of high finance, and a legal system that's frankly still figuring out how to deal with digital things. What is property online? What's a trade secret when code is involved?
Yeah, the definitions themselves were thought over in court. Like, is code a good?
Exactly. And for you listening, maybe one aha moment is seeing how the same action downloading code could be viewed so differently. Criminal theft by Goldman, but kind of standard practice, or at least understandable by many fellow programmers.
That difference in perspective is stark. And the sheer intensity of Goldman's reaction may be fueled by more than just the code itself. That's striking too.
And Sergey's own resilience through it all, years of this uncertainty.
So it really pushes us to ask, doesn't it? What does this whole story tell us about owning information, owning ideas, in a world run on the code? How valuable is digital stuff, really?
And how does the law catch up? Or should it catch up? When you look at the whole arc, federal conviction, acquittal, state charges, conviction, dismissal, reinstatement, time served, does that feel like justice? Was justice truly served here? It's hard to say definitively.
Leaves you with a lot to chew on. We definitely encourage you to think about those different angles, the programmers, Goldman's, the legal systems. And maybe look more into intellectual property in tech or how high-frequency trading actually works.
Yeah, it's a case that touches on so many big important themes about our modern world. Really fascinating and definitely relevant.